Ready, start. If the custodian himself cannot be constituted to be the owner of the enemy property, then much less the central government or union can be considered to be the owner of such property. Full stop. In our view, the union or the central government cannot usurp rights of ownership and exercise all such rights of ownership vis enemy property. Full stop. In the absence of any provision conferring such ownership on the custodian, the central government, which appoints the custodian of enemy property in India by issuance of a notification in the official gazette to carry on his functions under the provisions of the act, cannot assume ownership rights over such property. Full stop. The same is having regard to the fact that the act is a piece of parliamentary legislation and therefore, the state legislatures or governments have no competence to take steps under the act and therefore, the central government appoints the custodian of enemy property in India. Full stop. However, it was contended by Sri Balbir Singh, learned ASG, appearing along with Sri Rupesh Kumar, learned counsel for the custodian, that by the appointment of the custodian by the central government, the powers of the custodian in respect of enemy property vested in him and such other actions that he may take vis-a-vis enemy property, would clearly indicate that the custodian acts at the behest of the central government and therefore, the enemy property becomes union property even though the same is vested in the custodian who, in any case, is appointed by the central government. Full stop. In order to buttress this submission, our attention was drawn to section 8-A, which begins with a non-obstante clause and which states that the custodian may, with the approval of the central government, dispose of enemy property by sale or otherwise, as the case may be, the enemy property vested in him immediately before the date of commencement of the Amendment Act, 2017, in accordance with the provisions of the Act as amended by the Amendment Act, 2017. Full stop. Further, the custodian, on disposal of enemy property, has to deposit the sale proceeds into the consolidated fund of India immediately and intimate details thereof to the central government. Full stop. Also, the custodian has to submit a report of the enemy property disposed of including details of sale etc. Full stop. The central government may also issue directions and guidelines to the custodian in matters related to disposal of enemy property which are binding on the custodian and the buyer. Full stop. Moreover, the central government may deal with or utilize the enemy property in a manner as it may deem fit. Full stop. On sale of any enemy property vested in the custodian to any person, he may, on receipt of the sale proceeds of such property, issue a certificate of sale notwithstanding the fact that the original title deeds of the property have not been handed over to that transferee. Full stop. That once such certificate of sale is issued, the same shall be valid as conclusive proof of ownership of property by such person. Full stop. Further, the certificate issued by the custodian shall be a valid instrument for registration of the property in favor of the transferee as the registration in respect of enemy property for which such certificate has been issued by the custodian, shall not be refused on the ground of lack of original title deeds in respect of such property. Full stop. In our view, although custodian for the enemy property is empowered to alienate enemy property under the provisions of the Act, he does so as a trustee of the said property and not as the owner thereof, or as the central government being the owner. Full stop.